Telecom Draft Bill 2022, analysis of the bill, issues and the controversy around it. Introduction. With 117 crore subscribers, India is the world's second largest telecommunication ecosystem. The sector employs more than 4 million people and contributes about 8% of the country's GDP. The existing telecommunication sector is based on the Indian Telegraph Act of 1885. The nature of telecommunications, its usage, and its technologies have undergone a massive change since the era of the telegraph. The world stopped using telegraphs in 2013. 10 sections make up the entire Telecom Draft Bill 2022. It suggests that a new statute and a more straightforward regulatory structure are required. While the law highlights some of the crucial concerns that must be resolved in this reform, it glaringly leaves out some crucial details. We now live in the era of technology such as 4G, 5G, the Internet of Things, Industry 4.0, end-to-end communications, mobile edge computing, etc. These technologies are creating new opportunities for India's socio-economic growth. Therefore, India needs a legal framework attuned to the realities of the 21st century. The modes of communication have changed in the last several decades. The present laws governing the telecommunication sector were not sufficient to address the issues faced today. As multiple players and services have multiplied over the last 10 decades, the law has to keep up with the changing times. The time has now come for a change in the 100 years law. The current laws governing the telecommunication sector include the Telecom Regulatory Authority of India TRAI Act 1995, the Indian Telegraph Act 1885, the Indian Wireless Telegraph Act 1933. The evolution of the telecom sector started only after the government separated postal and telephonic services by setting up the Department of Post and Department of Telecommunication (DOT). The need arises for a new bill as the telecom and digital communication industry has far outgrown the Telegraph Act of 1885. The bill aims to bring sweeping changes to how the telecom sector is governed. It will cater to the era of 4G and 5G, the Internet of Things, end-to-end communication, mobile edge computing, and Industry 4.0. Three crucial facets of telecommunications: telecommunication services and networks, telecommunication hardware and infrastructure, and the spectrum including its assignment are all subject to central government regulation under the bill. The bill applies to any entity that provides telecommunication services, operates a telecommunication network, owns telecommunication equipment and infrastructure, and is assigned or seeks assignment of spectrum. Analysis of the bill. In a bid to regulate the dynamic tech space, the central government has finalized the Telecom Bill 2022. The bill was also consolidate the three laws currently governing the telecom industry: the Indian Telegraph Act of 1885, the Wireless Telegraph Act of 1993, and the Telegraphy Wireless Unlawful Possession Act of 1950. The bill has proposed many changes to the Telegraph Act, and these changes will have profound impact on the telecom sector. For example, the bill has introduced the term telecommunication services in place of the telegraph, which has helped to clarify the types of services and technologies which will fall under the regulatory ambit of telecom regulations. Broadcast, voice and data services, all of these will fall under its purview as before, but internet services like WhatsApp, other popular video conference apps and email will also fall under the ambit of this bill. It removes some ambiguity in some matters. The draft bill also provides for penalty waiver in extraordinary situations of financial stress like insolvency and bankruptcy. The government will remain the custodian of spectrum assets owned by the company if the company falls into bankruptcy. In case of insolvency, the spectrum will revert to the government. Right now, there is no clarity about who owns the spectrum. If an operator defaults, does it belong to the center or can banks take control? The bill provides the answers and there is clarity, so this will avoid court disputes like the ones involving the dissolution of Reliance Communications. Here, the court order states that the spectrum owned by the firm can be sold under the insolvency process after the government dues are cleared. It also introduces a clause to provide waivers to operators to allow the government to those operators who are unable to pay their dues. Over-the-top services. OTT or over-the-top platforms are audio and video hosting and streaming services which has started as content hosting platforms but soon branched out in the production and release of short movies, feature films, documentaries and web series themselves. India is the currently world's fastest growing OTT market and is all set to emerge as the world's sixth largest by 2024. The bill expands the definition of telecom services to include OTT services. This means that for the first time, services such as WhatsApp, Telegram, Signal, etc. will now be subjected to regulation under the telecom regime. Firstly, we need to understand this. OTT platforms like Netflix, WhatsApp, etc. use a carrier or carriage, that is, the internet like Airtel or Jio, to bring the content or messages to our devices. We pay Netflix for the content and we pay Airtel or Jio for the internet. Democratization of content has been overwhelming. Any developer who spots a bug or a problem can just build an app, put it out in the market and let the users pay for it without any permission from the government or the internet service providers. This low entry barrier is the sole reason why apps like Facebook, Telegram, WhatsApp and every other evolutionary app has been able to change the lives of billions of people across the world. The issue. However, the very same government that talks about Digital India and the need to encourage digitalization is putting a big hurdle for most revolutionary services India has ever seen. In the draft bill, the government has included internet-based and OTT communication services such as WhatsApp calls, FaceTime and Google Meet under the definition of telecom services, and it is meant to bring a level playing field in the telecom space because today, while telecom companies need a license to offer services, OTT platforms like Netflix, Hotstar, Amazon Prime Video, etc. do not need to go through those hurdles. So as per the draft law, any service made available through the internet will be under the central government's purview. So if tomorrow a developer develops an app, he or she will need a license from the government to operate. The aftermath of this law would be, first of all, apps like WhatsApp and FaceTime might have to buy 500 to 600 crore license, and where they are going to recover that money from people like you and me. The worst part of all this is that it is not the operation of these apps that have become costly, but the government wants to level the playing field for Jio, Airtel and WhatsApp. Secondly, developers will need a license from the government to roll an app out to its users. This sits heavily on the creativity of developers, killing their innovation. The government has justified this by stating national security as a reason behind all these restrictions. This provision also poses administrative questions too. To impose license fees, the government will have to determine the revenue accrued from internet communication services, but most apps are free to use and they earn revenue from partnerships with businesses which are not typically under the ambit of telecom services. The spectrum. The bill recognizes the power of the government to assign spectrum not merely through auction but also allocation. The bill also brought changes in provisions addressing spectrum management. The Department of Telecommunication has proposed that for a telecom entity in possession of spectrum goes through bankruptcy or insolvency, the assigned spectrum will revert to the control of the center. Right now, the Telegraph Act does not govern how the government provides its spectrum to telecom service providers. Processes through which spectrum will be provided to operators were decided in an ad hoc manner, and mistakes in this process would cause strain on the courts, leading to the Supreme Court verdict in the 2G scam, after which spectrum for telecom services started to be auctioned. Now, the centre wants to take back control of spectrum management for the first time since the Supreme Court's verdict. The spectrum can, however, be allocated through the administrative procedure for research, transportation and other purposes. The DoT has also suggested that the given spectrum would return to the centre's authority if a telecom business in possession of it filed for bankruptcy or become insolvent. According to the bill, the spectrum can be assigned administratively in addition to an auction, which is how it is currently assigned. Also, the draft bill gives the centre the powers to defer, convert to equity, write off or grant relief to any licensee under extraordinary circumstances including financial stress, consumer interest and maintaining competition. This could be a big benefit to Vodafone and Idea, and it could help the government keep more players in the industry. An assignment should be done for the common good principle rather than generating revenue for the government as per the words of the bill. Legal issue. A licensed telecom service provider today must compulsorily provide access to your network to law enforcement authorities so that they can intercept messages during an investigation. Apparently, as of now, digital communication apps have no obligation to share all this data with the law because they do not fall under the definition of licensed telecommunication service. Because of this encryption used by these apps, it becomes very difficult for the government to identify and punish criminals. This is the main reason why government wants to bring apps like WhatsApp, Zoom, email and FaceTime under the licensing regime. According to the bill, the service provider could be subjected to licensing and other types of regulations just like a typical telecom service provider. Experts are concerned that user anonymity and privacy could be compromised as a result. The bill proposes that its users utilizing internet communication services will have to disclose their identity while signing on to these services. Experts have argued that if lawful interception is the issue, then the IT Act already has provisions, Section 69, to enable lawful interception and monitoring of messages that are sent through digital communication applications. Even then, the government is putting forth the argument for national security. Now, whether this is good or bad, I'll let you be the judge of that. The bill also gives the government the power to block certain messages from being transmitted, besides that it also equips the center to intercept any or a clear class of messages the government has justified by citing national security. This could impact and threaten the end-to-end encryption of many services. Therefore, the right to anonymity and right to privacy that many users take for granted by utilizing internet communication services could be compromised. Tech companies like WhatsApp would find it hard to implement some of these provisions like disclosure of identity due to end-to-end encryption used in these apps. The bill now has the legal standing of special legislation. It takes precedence over any inconsistencies found in any other law now in existence. The Information Technology Act 2000, India's primary electronic format law, may be directly impacted by this. Which rule would take precedence if these two laws conflicted? According to legal precedent, the law passed later, if it contains a clause giving it an overriding effect, will take precedence if there are two special laws. Given that the Telecom Bill will be passed after the IT Act, it would appear that it will triumph. Know your customer and caller identification requirements. According to government-specified verifiable mode, the bill requires licensed entities to identify the people to whom they offer telecommunication services. The licensed companies must have caller ID-like features that let message recipients know who sent them. The bill requires telecommunication service providers to carry out this duty through a verifiable mode, which the government has yet to specify. The perspective of this bill is quite positive as it targets solving problems in society like OTP frauds, online scams and cyber fraud. Remember, when you sign up for an app, website or online course, guess what? The moment you enter your mobile number, not only does that company's sales team call you, but also the sales team of a real estate company, a credit card company and banks who are willing to give you loans for no reason at all. But with the Telecom draft bill, this will be curtailed because the draft bill proposes that the identity of the person communicating using any form of telecommunication service shall be available to the user receiving such communication. Now, the name of that person will be displayed by default on your caller ID. And the best part is that this is not just applicable to voice calls but also to the users of OTT communication services like WhatsApp and Signal. And if these people do not complete their identification, there will be a 50,000 rupee fine, suspension of the mobile number and banning the person from using these telecom services over a certain period of time. The draft bill also states that the even advertising and promotional communication should be only made with the prior consent of a subscriber. The Department of Telecommunications (DOT) and telecom carriers have been refining Know Your Customer, that is KYC obligations, for many years. Users might not always want their identities to be revealed to the recipients of each message, though. A user might not want their identity revealed or verified when responding to a survey or denying a service, for instance. The bill outlines the obligations of users to refrain from providing false information, withholding important information, or impersonating others when verifying identity to access telecom services. We can now expect a future without these annoying spam calls and spam messages. It's essential for law enforcement agencies to be able to keep an eye on ill-gotten gains made through OTT platforms. The majority of financial online scams take place over OTT calls. As a result of the lack of data availability and traceability, it was impossible to identify the perpetrators. The bill focuses on the protection of the users. Security issues. The provision on internet shutdown is a bit critical. For the first time in the Indian legal framework, a specific provision is enabling the government to order the suspension of internet power. However, the major concern is that in case of riots and chaos, the government should not use an internet shutdown as a means of curb the voices of the victims. Because of this provision, it is misused. The politicians can use an internet shutdown to orchestrate a riot, and that will be dangerous. The following issues have been brought up by civil society. The bill gives the central and state governments the authority to intercept messages in the event of an emergency or the interest of public safety without any accompanying checks and balances. There is no definition provided for national security. Why was it necessary to include Section 69 of the Information Technology Act 2000, which grants the right to intercept messages sent through computer resources in the proposed bill? The bill should include the specific consequences and fines for deviating from service providers' behavior. Developing procedures and putting restrictions in place that make accounts connected to terrorist groups accessible to law enforcement agencies in real time is a challenge for both social media sites and governmental organizations. It should not be construed as privacy to protect conversations between traffickers and terrorists. Even if their posts are hidden by privacy settings, platforms are aware of these users and can see what they are publishing. Owners of social media platforms need to realize that privacy and freedom are not binary concepts. To ensure our safety, a balance must be struck. Additionally, the government must reassure the populace that law enforcement will not abuse this right for ulterior political or other purposes. There should be some kind of oversight, ideally parliamentary. Role of regulators. The Independent Sector Regulator, the Telecom Regulatory Authority of India, and the Telecom Dispute Settlement and Dispute Tribunal have their roles considerably reduced by the draft Telecom Bill, that is TSAT. The bill aims to eliminate clauses allowing the DOT and TRAI to reference and refer back to recommendations. It gives the DOT more authority to make policy-related decisions without first contacting TRAI as required by law. As a result, the DOT will have more power over policy making, the TRAI's role will be diminished, and the mechanism of checks and balances between the policy maker, that is TRAI, and the licensee will be eliminated, which is DOT. Only at the Telecom Department's request will TRAI be permitted to make suggestions. Since the idea of regulating OTT services was initially put up in 2015, it has been a source of controversy. According to TRAI's directive, there was no need to regulate OTT services as of September 2020. A new round of consultations to assess the benefits of OTT regulations was requested from TRAI to begin in August 2022. The current consultation process might become meaningless in light of the draft telecom law. According to the draft bill, OTT services must be licensed unless the government agrees to exempt them. The government will no longer be required to take the regulator's recommendations into account as a result of TRAI's diminished position. Conclusion. It is commendable that the government took the initiative to create the draft communications law. It is commendable that the method being used, which involves posting it in the public domain and soliciting suggestions and opinions from everyone before finalizing the bill and taking into account the worries of many stakeholders, have been followed. It will be impossible to please everyone due to the complexity and frequent contradiction of the topics. Everyone should be able to agree on the legislation as long as an attempt is made to make it more useful, current, and effective. A crucial part of using the internet and cyberspace is telecommunication. Newly developing technologies like AI and the IoT and blockchains have a direct impact on them. Within the borders of India, there is telecom. Digital applications, however, extend beyond India's borders. The question of bringing some of these under telecom would be challenging. The proposed law should incorporate futuristic, broad, generic provisions pertinent to the introduction of new technologies because India is unquestionably going to the future. Telecommunications play a significant role as a crucial information infrastructure for India's cyber sovereignty. The time has come to define guidelines to ensure the protection of Indian security, sovereignty, and integrity in the telecommunications and cyber sovereignty domains, since there are no specific legal provisions on the subject in India. Aspects of cybersecurity must be explored in depth. Both national security and individual citizen privacy are crucial. You cannot exchange one for another. An independent body under the control of the Parliament must control the arbitrary power of surveillance and demand accountability and openness from law enforcement. We hope this bill would cater to both national security and individual privacy. Thank you so much for watching and stay tuned to India Business Insights for more such videos. Also, don't forget to like, share and subscribe to our channel.